All right, everyone, I have that it is 2 p.m. Are you able to hear me?
Yes, Your Honor.
All right, thank you. This is the State Expedited Accusations calendar. Today is June 29th of 2022. I am Judge Melanie Williams. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. All participants, this proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means that any member of the public can log on and watch this particular proceeding. To all defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceedings today. At the jail, before we begin, are there any medical resets on the calendar today?
No, Judge.
All right, thank you. And I see that we need a breakout for Trammell case. Will we need a breakout for any other cases today from either the state or the defense? I'm hearing none. I'm gonna assume that position 12 is the only case for which we will need a breakout. I'd like to do all the breakouts together if possible. Who do I have first?
It should be position number 3, Ms. Curry, please.
Okay. Good afternoon. Are you Tia Curry?
Yes, ma'am.
Your case number is 22 CR 004138A, in which you're charged with battery with the offense date of June the 28th of 2022. Do you understand the rights that I just explained to you?
Yes, ma'am.
All right. Who do I have for pretrial? Mr. Howard, good to see you this afternoon. What is Ms. Curry's history?
First.
All right, thank you. Recommended, I'm assuming. All right, whose case is this for the state?
It's my case, Your Honor.
Oh, good to see you, Mrs. Segura. What is the state's recommendation?
Good afternoon. This case occurred on June the 28th, 2022 at the instant location of 395 James P. Wally Drive, Northwest Atlanta. In this instance, officers there was an altercation outside of this residence, which is a park area. At this point, officers came out and spoke with the defendant, who said that there was altercation between her and the victim, a Miss Robin Asia Whiteside. Robin Asia spelled ROBYN-ASIA, Whiteside, common spelling. And according to Miss Whiteside, there was a altercation because the kids were in a disagreement earlier and they were not getting along. At some point, the defendant struck Miss Whiteside in the face and a mutual fight began. After this, Miss Whiteside experienced some visible injury to her right facial cheek, her elbow, and her knee. Because of this, the state's recommendation is a $3,000 surety bond, 1-day anger awareness, no alcohol, drugs, and weapons, and no further contact with Robin Asia Whiteside. We recognize this is the defendant's first arrest, but even so, there was a mutual combat in a public space, which was near a park area, and we're not sure how. And because we couldn't contact the victim because she is also was arrested as well, we are uncertain as to what the facts led to this altercation. Just let's be on the safe side, and especially for Ms. Whiteside, we're asking for the surety bond. Thank you.
Thank you. At this time, I'm going to sound for Ms. Whiteside. Ms. Whiteside, if you are present on the Zoom conference, this is your opportunity to speak. Ms. Whiteside, are you present? All right, hearing none, who represents Ms. Curry?
Good afternoon, Your Honor. This is Attorney Sharice Challenger, representing Ms. Curry. My legal intern is here, which is she's a third-year law student. I wanted to see if she can speak on my behalf, and she will introduce herself to the court.
All right, and when you do your entry, Ms. Challenger, please just note that as well, that you had a co-representative. Thank you. All right,
yes, Your Honor.
Please proceed, Counselor.
Also, one thing, Your Honor, I do apologize in advance. We seem to have some type of difficulty in my office, so it seemed like the fire alarm is going off. So if you do hear it, that's what the issue is.
That's just fine, Ms. Challenger. Thanks for making us aware. Please proceed, Counselor.
Good evening, Your Honor. My name is Maya on behalf of Challenger Law Firm and Attorney Sharice. We are requesting a signature bond for Tia Curry. She is a 22-year-old with 2 children. She is a high school graduate and she is a longtime resident of GA. Alongside the signature bond, we're okay with no contact with her neighbor, the alleged victim, as well as a stay away, a request for a stay away.
All right, thank you.
And Your
Again, yes, Ms.
I'm sorry, I
Challenger.
just want to add a couple of other things too. She also is pregnant, Your Honor. She's 7 months pregnant. So we would just ask if she could be released on that signature bond. As the court is aware, this is her first arrest. My understanding for the alleged victim in this case is that they are neighbors. So the no further contact and the stay away would not be a problem as long as the stay away is particularly just addressed to the alleged victim's house.
All right, and I don't want you to indicate your client's entire address. What is your client's, just the numerical part of her address? So
Yes.
that we can clarify, just to make sure that the stay away order does not impede on her ability to return home.
Correct. The apartment address I have is 395 is the numerical portion.
So that's her address, not
Correct,
the
but
victim's address.
It's
So
an
Mrs.
apartment.
Segura, oh, the entire apartment is 395. What is her unit number? Are you aware of that?
Yes, A103.
Mrs. Segura, what is the victim's alleged unit number? Do you know that?
I do not, and because I believe that the victim's also a different defendant, I think a conflict attorney might have that information.
Okay, okay, the victim is a co-defendant. Okay, I didn't catch that part earlier. And I don't think she appears on this calendar. So what I'm gonna do is I'm gonna issue the stay away from the victim's address, the co-defendant's address. And I'm gonna ask that the state or defense supplement the record at some point with the actual unit number. Ms. Curry is gonna receive the $3,000 signature bond through pretrial services. She must complete the 1-day anchor awareness course. However, I am gonna require that. And the stay away address, I am gonna issue the stay away, but as I indicated, she can return to her own home, but she must stay away from the co-defendant / victim's address. And she is to have absolutely no further contact with Ms. Whiteside. Are there any questions from either the state or the defense regarding this ruling?
No.
No, Your Honor. May we be excused?
Yes, if you have no further business with the court, both of you all have a great day.
Are you
All
too?
right.
Thank you so much.
Thank you. All right, who do we have next?
Position number 4 here at South Annex. How you doing, Your Honor?
Thank you, I'm well. Let's say position 4. Is this Desiree Fairley?
Yes.
Okay. Ms. Fairley, do you understand those constitutional rights that I just explained to you?
Yes.
Okay, your case number is 22 CR 004139E, in which you're charged with battery with the offense date of March the 21st of 2022. I need to make you aware of your case number. All right, Mr. Howard.
The first adult arrest.
Okay, thank you. And Mrs. Segura, this is your case as well?
No, it is, yes.
All right, please proceed.
This case occurred on March the 25th, 2022, in which the officers responded to a call at the incident location, which is Club Wax, which is located at 4375 Commerce Drive, Atlanta. In this case, officers talked to the victim, Ms. Jacqueline McVeigh. Jacqueline, spelled JACKOLYN, McVeigh, MBAYE, in which she stated that the defendant approached her in the parking lot at that incident location, started to yell at her, pulled her hair, punched her in the face, then dragged her on the parking lot ground. At some point, she also took her car keys, then drove away. When police were able to talk to Ms. McVeigh, they noticed that she had 2 swollen black eyes, a small cut near her eye, and multiple bruises and abrasions on her knees and elbows from being dragged across the parking lot. Because of this, we are asking for a $5,000 surety bond, 1-day anger awareness, no alcohol, drugs, and weapons. Stay away from Club Wax located at the 4375 Commerce Drive, Atlanta location. And no further contact with Jackie McVeigh. Allegations are based on these facts. As well as we spoke with Ms. McVeigh earlier today and got more information. And because of this information, we're concerned by the safety of McVeigh because, as she stated, both McVeigh and the defendant are co-workers at the same location. She stated that the defendant was fired from Club Wax, but ended up returning back and began to fight with Ms. McVeigh. She also confirmed that she did sustain those two black eyes, cuts, and bruises. Alongside, she also stated that the defendant took her keys, which contained both her car keys as well as her house keys, and has not received those items back. Alongside, she also stated that the defendant has been harassing her by calling and texting from Google phone numbers. And so we are concerned about the safety, and based on what Ms. Faye has said, she also wants to have no further contact with the defendant. Thank you, Your Honor.
Okay, I'm gonna sound for Ms. McVeigh at this time. I believe I saw her on the Zoom conference. Ms. Jacqueline McVeigh, if you would like to make a statement, this is your opportunity to do so. You are not required to do so, however. Do you wish to make a statement at this time? If you wish to make the statement, are you in a safe location, Ms. McVeigh? It looks like you might be driving and you are muted, so we can't hear anything you're saying. You need to unmute your screen.
Location.
I'm sorry, Ms. McVeigh, we can't hear you. Ms. McVeigh, it still says that you're muted. Do you wish to make a statement? Okay, let's work on Ms. McVeigh muting it. In the meantime, Ms. Gannis, is this your case?
Yes, Your Honor. Good afternoon. Ms. Desiree Bailey is 23 years old. She has been in the Atlanta, Georgia area for 4 years. She does have family members here. Your Honor, we are unopposed to the stay away at the incident location. My client informs me that she no longer works there. Ms. Bailey completed high school. She is currently self-employed. She sells hair extensions. Your Honor, Ms. Bailey denies the allegation. She states that they, Ms. Mabay and my client were actually co-workers, and my client informs me that prior to this incident, the complaining witness had been stalking and harassing my client at work. And my client informs me that she is 120 pounds and that Ms. Mabay weighs a lot more than she does. My client does not have any prior convictions for violence. She is recommended for a signature bond. I am requesting a signature bond on her behalf. If Your Honor determines that she's ineligible, then a bond of no more than $1,000. And again, we are unopposed to the no contact and stay away provisions. Thank you, Your Honor.
Right. Thank you, Ms. Gant. Ms. McVeigh, I see that you've unmuted your screen. Would you like to make a statement?
Yes, ma'am.
Before you begin, please raise your right hand. Are you driving?
No, I'm in the back seat of a car. I just got off the airplane. I came home for the holiday and my friend picked me up from the airplane.
Okay, please raise your right hand. Do you swear and affirm that the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, Your Honor.
All right, what would you like to tell the court at this time?
Yes, I never harassed her. We were cool at first. I never did anything to harass her or anything. She's lying. And the thing is, I have video of her attacking me. So I don't know. I got the video and I sent it to the lady who called me today. And I just feel that she shouldn't, I want to restrain an order on her. I just feel very fearful for my life because of how she attacked me. And she took all my belongings out of my pockets. She went through my pockets and everything.
Okay, thank you.
And she had 3 other people with her, and she texted me all the time. I got text messages from her harassing me and threatening me. Saying I'm a snitch ass person, like a snitch person. I'm 52 years old. I'm old enough to be her mama, and I might be a little bigger than her, but they don't give her the right to come in and jump me the way she did. It doesn't matter what size I am. I'm old enough to be her mama.
Yes, ma'am. All right. So
Yeah,
you do fear, Miss, you do fear the
Yes, I
defendant, you
do.
wish to have no further contact, is that correct?
Yes, yes, Your Honor, I do. I fear for my
Thank-
life.
All right, I appreciate that, Miss McVeigh. Thank you for coming to court and making that statement at this time. Is there
Thank you
anything
very
further?
much, Judge.
I appreciate that. Is there anything further from either the state of defense?
may I ask Ms. McVeigh a couple of questions?
Very briefly, Mrs. Segura, I believe that your case has been thoroughly set before you, and I think it's on the record that she wishes to have no contact. So if I feel that the line of questioning is excessive or unnecessary, I will terminate it. Go ahead, Mrs. Segura.
Ms. McVeigh, can you
Your Honor.
explain your injuries again?
Your Honor,
I had two black marks on my two black eyes on both sides of my right and left side. I have bruises on my knees, on both of my knees, where I fell to the ground when she yanked my hair. She pulled out my dreads too. So I mean, I'm just I have bad dreams every day. You know, nightmares, not even dreams, but nightmares about this incident that happened 3 months ago.
All right, thank you. Mrs. Segura, are you intending to ask any additional questions? I think the court has a great understanding of what took place. Ms. Gant? All right, Ms. Gant, would you like the opportunity to cross very briefly?
no, Your Honor. I was saying that my internet blanked out, but I got the gist of what transpired. And I also want to just bring to the court's attention that my client, upon learning about this warrant, did turn herself in, Your Honor.
All right, thank you. All right, at this time, I am going to accept the state's recommendation. The defendant's going to receive a $3,000 surety bond. She is to have no further contact with the victim, last name McVeigh. She must stay away from the Club Wax location at 4375 Commerce Drive, and she is to have no weapons, drugs, or alcohol as a condition of that surety bond. She will be reset to the SAP calendar on July the 12th of 2022, as she has received a surety bond, where these conditions and her bond amount can be revisited at that time. All right, I believe that concludes this case. Is there anything further from either party?
No, Your Honor.
Nothing
All
further
right.
from the defense.
All right.
That'll be all
Best of luck to
that.
you. All right, who do we have next?
We have position number 2, Mr. Collier. Can you take these down?
All right, are you Frederick Collier?
Yeah, yes, Your Honor. You gotta excuse me. I'm hoarse. My glands and my lungs are
Don't say too much, Mr. Collier. Just I don't want you to say something by mistake. Mr. Collier, your case is 22 CR 004136J, in which you're charged with criminal trespass and theft by shoplifting with the offense date of June the 28th of 2022. I understand that you're hoarse today, but just indicate to me whether or not you understand the rights that I've explained to you previously.
Yes, ma'am.
Thank you. All right, Mr. Howard.
12 total. Last arrest was in March, criminal trespass on Marta. Got a 2015 probation violation for battery DV out of the cab. 2014 probation violation, same charge. Come off of a 2014 conviction along with a disorderly conduct. 2013 probation violation, battery DV. 2011 trespass. Let's see. He had history out of state in Indiana, but that was back in the 90s. And a 2012 arrest in Louisiana. I have no idea what that charge is.
Okay.
But that's it.
All right, thank you. Mr. Segura?
This case occurred on June 28th, 2022 at a Walgreens located at 25 Peachtree Street, Southeast Atlanta. In this case, officers were dispatched to a shoplifting call at this Walgreens. Upon arrival, they met with the store manager, a Miss Janelle Reed, Janelle spelled Janelle, Reed, common spelling, who reported that a defendant came into the store, walked to the back, and grabbed 2 8-packs of 16-ounce beers, Bud Lights and Budweiser. And the defendant took the bills, walked out of all points of sales, then fled the scene by paying for the items. At some point, the defendant came back for some reason, and when police were there, they arrested him. And when they got more information about him, they found out that he had a criminal trespass notice on that location from June the 6th, 2022. Because of this, the state is recommending a $3,000 surety bond, $1,000 for the criminal trespass, and $2,000 for the theft by shoplifting, no alcohol, drugs, and weapons, and a stay away from Walgreens, located at a 25 Peachtree Street, Southeast Atlanta location. Allegations are based on these facts, as well as some concerns about the defendant has a risk of reoffending while he was on a bond, because as Charles noted, he does have a 2014 probation violation arrest. Alongside, in 2011 he did do criminal trespass, and he does have the criminal trespass arrest from March 11 of 2022. Because of these concerns, we're asking for a surety bond. Thank you.
All right, thank you. Ms. Gant?
Thank you, Your Honor. Mr. Frederick Collier is 46 years old. He has been in the Atlanta, Georgia area since 2005. He has 2 children, Your Honor, ages 14 and 15. He does have child support orders and is paying child support, Your Honor. We are unopposed to the stay away at the incident location. Mr. Collier completed high school. He is now unemployed and has been so for the past 3 weeks. Prior to becoming unemployed, he worked as a dishwasher. He was in that position for about 4 or 5 months. He is currently looking for a job. Your Honor, I do acknowledge my client's history. We are denying the allegations today, and I would just point out to Your Honor that I did not hear about any FTAs, and I do believe that the probation violation is rather remote, 2013, 2014. Given his ties to the community and his inability to pay, coupled with the nature of the offenses, I am requesting a signature bond. And if Your Honor determines that he is ineligible, then I've asked for the lowest bond possible, no more than $500 for the criminal trespass and $500 for the theft, for a total of $1,000. Thank you.
All right, at this time, Mr. Collier is going to receive a split bond. He's going to receive a $1,000 surety bond for the criminal trespass and a $1,000 signature bond through the jail for the shoplifting, for a total of a $2,000 bond. He is to stay away from that Walgreens at 25 Peachtree Street and have no weapons, drugs, or alcohol as a condition of this split bond. He will also be reset to that SAP calendar on July the 12th, 2022, in light of the fact that he received a surety bond at this time. Is there anything further from either the state or the defense?
No, Your Honor.
Nothing further. Thank you, Your Honor.
All right, best of luck to you, sir. Who do we have next?
We have number 6, Mr. Jackson.
All right, good afternoon, Mr. Jackson. Your case number is 22 CR 004141A, and what you're charged with criminal trespass with the offense date of June the 28th of 2022. Do you understand your constitutional rights?
Yes.
All right, Mr. Howard.
6 total. Last arrest was January for obstruction out of Paulding County. It appears to be open. He has a holdout of done with it, failed to appear for a public order crime. September 2021, trespass, family violence. That goes with the obstruction. He has history in Florida, 2014, guest refused to leave, defrauding innkeeper, resisting arrest without violence. Got a 2020 North Carolina, 2nd-degree trespass, simple possession of a Schedule 6 controlled substance. Those were dismissed. And I got a misdemeanor larceny that was dismissed in 2020 also, out of North Carolina. That's it.
Okay, thank you. Mrs. Segura?
Accused occurred on June 28th, 2022 at the Greyhound station located at 232 Forsyth Street, Atlanta. In this case, he was also on the scene when he was flagged down by Mr. Emari Cosby. Emari, spelled E-M-A-U-R-I, Cosby, common spelling, who was a security guard at that Greyhound station. He told the police that the defendant was at the location earlier in the day, and he was told to leave, but he refused and sometimes just remained. When the police approached the defendant, the officer also told the defendant to leave, but that defendant refused to and said that he was not going anywhere and was not leaving. Police tried to ask him a couple more times to leave, but he didn't do so until the police were forcefully took him off from the scene and arrested him. The state is recommending a $2,000 surety bond, no alcohol, drugs, and weapons, and a stay away from the Greyhound station located at the 232 Forsyth Street, Atlanta location. Recommendations are based on these facts, as well as with concerns that he is a risk of reoffending, as he does have that failure to leave from Florida 2014, as well does have an obstruction of law enforcement also from January of this year. And we also have concerns that he could be a flight risk, as he does have that open FTA warrant that's from December the 1st, 2021. Thank you.
All right, thank you. Ms. Gant?
Thank you, Your Honor. Mr. Shakir Jackson is 29 years old. He informs me that he does not have any family in the Atlanta, Georgia area. Therefore, he doesn't have any one to assist with bond. We are opposed to the stay away at the incident location. My client denies the allegations, and he informs me that he was a ticketed passenger and he was there basically asking the personnel to assist with his ticket to find out when the next bus would be leaving. He informs me that he originated from, I forgot where he originated from, but he told me that he was delayed in North Carolina. He was also delayed in Atlanta, and he ultimately was trying to get to Orlando, Florida. Mr. Jackson completed high school. He is unemployed at this time and has been so for a moment. Therefore, he does not have the means to pay anything toward bond. Since he does have the hold, I would ask that Your Honor grant a signature bond given the nature of the allegation so that he may be released to that hold in Dunwoody. And if Your Honor determines that he's ineligible, then I would ask for a bond of no more than $1,000, or Your Honor, in this case, the lowest bond possible. Thank you.
All right, thank you, Ms. Gant. At this time, Mr. Jackson is going to receive a $500 surety bond. His case will be reset to the SAP calendar on July the 12th of 2022 as well. He is to stay away from that location as a condition of this bond on Forsyth Street, and he is to have no weapons, drugs, or alcohol as a condition of this bond.
And Your Honor, for clarification, is the stay away from all Greyhound locations or just the incident?
Just that one, just that one.
Thank you, Your Honor.
All right. All right, best of luck to you, sir. Who do we have next?
Yeah, number 9, Mr. Onyeye.
All right. All right, good afternoon, Mr. Onyeye. Your case number is 22CR004137C, in which you're charged with simple battery family violence with the offense date of June the 28th of 2022. Do you understand your constitutional rights?
Yes, Your Honor.
All right. Mr. Howard? If you're speaking, we can't hear you. You're muted, Mr. Howard.
What number are we on? Number 9?
Number 9 on Onyeye.
This is third arrest. Last arrest was 2019 in Gwinnett. It was for a CWAC charge. It was indicted and later non-prosed. 2016 battery DV out of the cab. 3 counts, 1 count disorderly conduct. Those were dismissed. That's it.
Okay, thank you. Ms. Tortorello?
Yes, Your Honor, I have something different on mine, criminal history.
Okay.
I see 3 cycles, and I just sent you who's representing him for Miss Kim. I'm gonna send Miss Kim.
What history do you
Okay,
have?
I apologize. I think you sent it to my cell phone. I'm on this Zoom conference twice. If you could send it to my computer, because it only pops up for a second. I didn't see it, Ms. Tortorello.
Okay, I'm sorry.
It's okay. I shouldn't be on here twice, but it makes it easier for me to do the calendar this way.
Did you get it, Your Honor?
Yes, I have it now. Okay, I'm gonna ask that you send that to pretrial as well. Mr. Howard, can you verify those?
Is that the CWAC charge I called out?
I don't think so. No.
Mr. Howard, let me pull you up here. Pretrial. I also send it to opposing counsel.
Yeah, I think that's what Mr. Howard mentioned.
Is
about
that not
the
C, that's
charge.
the CWAC charge, that's what
Yeah,
I'm.
what accounting?
Oh,
That is what you said. Okay, I'm sorry. Go ahead, Ms. Tortorella.
Yes, Your Honor. For this case, we're recommending a $3,500 surety bond. The conditions is that you have no contact with the victim, Adebisi Depriver, and it's spelled A, D as in dog, E, B as in boy, I-S-I, and the last name is spelled D as in dog, E-P-R-I, V as in Victor, E-R for the record, that he stay away from 120 Ralph McGill Boulevard Northeast, apartment 513 in Atlanta, and that's the incident location. No drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, on June 28th, 2022, SPOL Suter of the Atlanta Police Department and Sergeant D. Hall were dispatched to 120 Ralph McGill Boulevard Northeast, the incident location in Atlanta, regarding a domestic dispute. Upon arrival, the officers met with the victim, Adebisi Depriver, and the defendant, Fabulous Onyanye, outside of the building. Ms. Depriver advised officers that a verbal dispute began between her and the defendant, who is her husband. Ms. Depriver said that at some point, the defendant started to slap and push her while he was yelling at her. Ms. Depriver called 911, but the call was disconnected. Dispatch attempted to call back multiple times, but was unsuccessful. The defendant was arrested, and all these events did occur in Fulton County, Georgia. Your Honor, we did have contact with the victim. She said that she and the defendant are married, they live together, they share a child. The victim stated that this has never happened before, and she does not fear the defendant. She wants contact, Your Honor, but however, there hasn't been a sufficient cooling off period, Your Honor. This happened yesterday, so we are asking for that no contact at this time, the $3,500 surety bond, due to, we also fear that he will reoffend and commit not only offenses while out on bond, but violent offenses given his record, and with the conditions imposed, Your Honor. Nothing further.
All right, thank you. I'm going to sound for Mr. Depriver at this time. Mr. Depriver, if you are present on the Zoom conference and wish to be heard, this is your opportunity to speak. Does anyone see Mr. Depriver on the Zoom conference? I do not. All right, seeing and hearing none, we're going to go to Ms. Kim.
Yes, Your Honor. Mr. Oyene is 36 years old, and he says that he does not live with his wife. They're married legally and yet separated physically. Mr. Oyene has been here in Georgia for more than 10 years, and he has 3 children, 2 in Georgia, and his son, they have a son together who is 16 years old. And he has been unemployed for the last 3 years because of different circumstances that he's going through. He is currently doing music as a career, and he has a bachelor's degree for information technology. He does not have any kind of addiction issues or severe health issues. He is recommended for a signature on bond by pretrial services. His past histories they are all dismissed, and he's presumed to be innocent, and we would like to request for a signature on bond. Thank you.
All right. At this time, the defendant is going to receive a $3,000 surety bond. He is to have no contact with the victim, last name Depriver, and he is to stay away from that incident location, and he is to have no weapons, drugs, or alcohol as a condition of that surety bond. His case will be reset to the SAP calendar on July the 12th of 2022, where this can be revisited at that time.
Hey, Judge, you say it again, our computer froze. We didn't hear it.
And you received a $3,000 surety bond. If you have questions, please follow up with Ms. Kim, who can answer more specific questions for you. All right. All right. Best of luck to you, sir. I believe that will conclude this case if there's nothing from the state or the defense.
At number 10, Mr. Patterson.
All right, good afternoon, Mr. Patterson. Your case number is 22 CR 004140J, and what you're charged with simple battery, family violence, and criminal trespass with the offense date of June the 28th of 2022. Do you understand your constitutional right?
Yes, ma'am.
All right, Mr. Howard,
Who is this? I had to step away real quick. I'm sorry.
position 10, Patterson.
This is ninth arrest. He don't have any violence from what I saw. 2020, abandonment of a dependent child was the last arrest. 2019, probation violation out of Carroll County. That's a felony probation violation. Drugs not in original container. Possession of a controlled substance. DUI from 2019. 2018, probation. 2017, probation. 2016, probation violation. It all stems from drug possession.
Okay,
That's it. But
Thank
yeah, I
you.
didn't see any violence on the system.
okay, thank you. All right, Ms. Tortorello.
Yes, Your Honor. For the simple battery family violence, a $2,500 surety bond. For the criminal trespass, a $2,500 surety bond. That's a total of $5,000. No contact with the victim. Her name is Michael Jones, traditional spelling for both a first and last name. That he have no, there be no third-party transfer of the child until custody issue resolved through civil court. My understanding is that defendant currently has custody of the child. So no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, there's an open case. It's a 21 CR 006396J. It's in a dormant bench warrant status. He's accused of simple battery family violence, and it involves the same victim, Michael Jones, where he placed his hands around her neck. The offense date is September 21st, 2020. So this is a subsequent offense, Your Honor. Not only is it a subsequent offense, but it involves the same victim. On June 28th, 2022, Officer Duncan and Officer Hurst of the Atlanta Police Department responded to 763 Cascade Avenue Southwest, the incident location in reference to a domestic dispute. Upon arrival, officers were able to speak to the victim, Michael Jones, who said that her child's father, the defendant Cedric Patterson, and his girlfriend, Taylor Thompson, assaulted her. Ms. Johnson said she arrived at the defendant's residence inquiring about the child because he would not answer her phone calls. Ms. Jones began to knock on the door several times and heard no answer, so she banged on the door and screamed, causing a disturbance. The defendant came to the door and asked her to leave, and Ms. Jones began to record him. Defendant stepped out and slapped the phone out of her hand, and in doing so, struck her hand. The incident was caught on Ms. Jones's cell phone camera, and it was reviewed by both officers at the scene. In the video, officers observed defendant smack the victim's hand and heard the victim say, "Don't hit me, Cedric." Officers further observed in the video Ms. Taylor Thompson stepping toward Ms. Jones and strike her several times. Defendant advised police he was the original caller because she was banging on the door yelling to see their child who was not inside the residence. The defendant said he asked Ms. Jones to leave several times, and that is when she called 911 so that police could do a welfare check on her child. The defendant said Ms. Jones has previously damaged his residence, property in his residence, and only came out to tell her to leave when she started banging on the windows. The defendant said she began recording and put the phone in his face, and that is why he smacked her hand away. Ms. Thomas admitted to striking Ms. Jones because she did not want the defendant to strike her. And Ms. Jordan and Ms. Thomas were cited with disorderly conduct, but the defendant, however, was arrested, and all these events did occur in Fulton County, Georgia. Your Honor, aside from that open case against the same victim you heard from pretrial, he was convicted of a felony possession of Schedule 4 controlled substance out of Carroll County Superior Court. This was under the First Offender Act in 2016. He has various violations of probations from 2019 out of Carroll County, 2018 out of Douglas, 2017 out of Carroll, and 2016 out of Douglas counties. No, I didn't see any FDAs. However, he was arrested for abandonment of deprived child out of Cobb County, and it was dismissed. This was out of 2020. He also was arrested in 2019 for, again, another felony drug charge, Your Honor. So for this reason, he does pose a risk of reoffending while out on bond, and not only reoffending, but also committing felonies while out on bond. And we have concerns of him intimidating the victim and witness in this case due to the second subsequent case against the same victim. And for that reason, we are asking for a total of $5,000 in surety with the conditions already stated. Nothing further.
All right, thank you. Very briefly, going back to Mr. Onyenye's case, I am going to add that he can have a third-party transfer of the child. So I'm just modifying position 9 for the record that he can see. I'm not terminating his ability to see his child. All right. All right, position 10, before I go to you, Ms. Kim, I'm gonna sound for Michael Jones. I see a Michael Jones on this Zoom conference. You are not required to make a statement. If you'd like to do so, this is your opportunity. You need to unmute and I need to swear you in. Can you raise your right hand if you'd like to make a statement? Do you swear and affirm that the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, and I am most interested today, Ms. Jones, in hearing about whether you wish to have contact with the defendant and whether you have fear and concerns about having interactions with him. But the court will hear your statement at this time. Go ahead.
I'm requesting a no violent contact order with the ability to transfer our child per the court order, of course. I would just like to let the court know that I will be filing an answer and counterclaim and a motion or a request for emergency hearing in light of what happened yesterday. That is all.
All right, do you fear the defendant? And I know you're asking for no contact with, to have no further violent contact. So you're saying to me that you wish to still have contact with him at this time?
Yes, ma'am, until this custody case is complete. I don't want to be cut off from contact with my daughter.
All right. All right, I think the court understands. Thank you for making that statement. Ms. Kim?
Yes, Your Honor. Mr. Patterson is 26 years old, and he says that there was custody order, and Miss Jones was there violating temporary protection order. I guess Mr. Patterson has a full custody until this custody issue is all resolved. So, I mean, that
was my question. So Mr. Patterson is actually the custodial parent?
Yes, Your Honor. That's what my client told me, that he has a full custody. And I believe that's what state also said, the defendant has a full custody.
We also understand, we were also told that, Your Honor.
Okay. Continue, Ms. Kim.
So she was not supposed to be there actually at all from the very beginning. They have 3 years old daughter, and of course they do not live together. He has a job as a chef. He's been working there for the last 8 years. He was born and raised here in Georgia. He has an associate degree from college. We would like to request for a signature on bond, and yet if Your Honor is not inclined to give him a signature on bond, we would like to request for a very, very low surety bond. And I believe in this case, I think his other charges are all drug related. And even though there's a bench warrant from 2020, it is obviously he's presumed to be innocent. So we would like to have a request for a signature on bond for him. Thank you.
I want to clarify one other point. There currently is a custody order in place that allows for visitation with Ms. Jones. Is that correct? Ms. Jones does not have any visitation at this point? Is anyone aware?
Your Honor, what we've been told by the victim is that there's a defendant has a custody of the child. The order, I guess, was done on June 23rd, 2022. Until the victim has a condition to complete, and I do not wish to state this on record, but she has a condition to complete before that custody situation is revisited, Your Honor. Your Honor, we are actually concerned. This just happened yesterday. There's not enough of a cooling off period that has occurred yet. To add, there's this custody issue going on, and there is an open case between these two parties, Your Honor. It just seems that they cannot have they can't have contact. It seems like the contact that they do have ends up to be violent. So for that reason, Your Honor, we are asking for no contact at this time, and that whenever that custody situation is resolved, that the victim and the defendant can follow the order.
I understand what you're saying, and again, I don't have the authority today to reach issues of custody, of course. But what I'm trying to figure out is if there's no third party that either the defense or state is aware of that could assist with the transport of this child, that this Ms. Kim, you're nodding no, so that seems to indicate.
Mr. Patterson, is it only about this custody issue that you are trying to address?
Yes, ma'am.
Mr. Patterson, I don't want you to say too much. The state is listening.
Yes,
The
ma'am.
only question I have is, and I'm going to ask you to please limit your responses to yes or no. Is there a third party that if I issue the no contact, could arrange the transport of the child between you and Ms. Jones?
Yes.
Okay. All right. I believe that addresses.
I have a question.
Ms. Jones, very quickly, go ahead. Very quickly.
I would just like to know who that third party would be, and I also just want to let the court know that I've always had custody of my daughter. This is the most recent order due to me missing court, but I do still very much would like to speak to my child.
Okay.
And I know you don't have anything to do with that.
Right. There's nothing I can do regarding that today, Ms. Jones. What I'm going to do is I'm going to ask Ms. Kim, please provide the court and Ms. Jones with the name of that third party. I think that is a reasonable request.
Sure.
At this time,
Your
Mr.
Honor,
Patterson.
I apologize. I'm about to send you something via chat, and I'm going to send opposing counsel before you make your ruling.
Very quickly.
Yes, there is a TPO with his mother involved. So if that's the third party, we need another one.
Did you get it, Your Honor?
Yes, I'm reading. Hold on. Okay, I understand the situation. And Ms. Kim, did you get it?
Oh yeah, I just got it, Your Honor.
Okay, so that's fine. Again, there's nothing I can really do regarding that. All right, at this time, Mr. Patterson is going to receive a $2,500 surety bond, $2,000 for count 1, $500 for count 2. He is to have no contact with Ms. Jones. They can arrange for the transport of the child through a third party. And he now this was another question that the court had. The incident location is her home or his home?
His home.
Okay, so I'm not going to issue the stay away, having information that is his home at this time. And the defense will provide the victim or the state with the name of the third party who will arrange for the transport of the child.
She has
All
no
right.
contact with my child in the order.
I'll talk to the.
I'm sorry. Was there a question, Ms. Kim?
I apologize. Mr. Patterson, please stay silent.
Whatever custody orders in place, the court has no authority to change those custody orders, but as a provision of this bond, you're not to have any contact with Ms. Jones. Should the custody orders change, the transport of the child will have to take place through a third party. They are not to have any contact as a condition of this bond.
Yes, Your
All
Honor.
right. Is there anything further from either the state or the defense at this time?
No drugs or alcohol, no weapons, Your Honor?
Yes, no weapons, drugs, or alcohol.
I would just like to say this is not the first time he has hit me.
Ms. Jones,
So-
the court is aware, I understand that the situation has been addressed. The entire ruling is addressed, and I believe that there will be further adjudication of this matter. This is just a bond hearing. All right, I believe that concludes this case. Best of luck to you, Mr. Patterson. Who do we have next?
Number 11, Mr. Ponder.
Okay, good afternoon, Mr. Ponder. Your case number is 22 CR 004143Y, in which you're charged with criminal trespass and possession and use of drug-related. Is Mr. Ponder coming?
Ponder.
Mr. Ponder, please come quickly. Did you hear your case number and do you understand your constitutional rights?
Yes, ma'am, yes, ma'am.
Okay, thank you for being responsive. All right, Mr. Howard.
15 total. Last arrest was March 2022, possession of drug-related objects conviction. He was also arrested for trespass. August 2021, trespass, that's open in state court. September 2020, trespass, 3 counts of shoplifting. Another September 2020 shoplifting. February 2020 shoplifting. January 2020 shoplifting, he pled NOLO to that and criminal trespass. 2019 shoplifting, 2019 theft by taking, 2019 criminal trespass, another 2019 trespass, that was a conviction. He got time served in 2018 for trespass. Well, 2 times in 2018. He got a terrorist threats, that was first offender, that and obstruction from 2015. That's it.
All right, thank you. Ms. Tortorella?
Yes, Your Honor. For the criminal trespass charge, you're asking for a $1,000 surety bond. For the drug objects charge, a $1,000 surety, and that's a total of $2,000. For the defendant to stay away from the incident location, the Chevron located at 1990 Donald Lee Hollowell Parkway Northwest in Atlanta. ADET, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, before I go through the facts, this defendant has 2 open cases. One is 21 CR 004265Y, where he's charged with criminal trespass. Offense date is August 14th, 2021. He was granted a $1,000 signature bond through the jail by Judge Morrow, where the imposed conditions were to stay away from the Chevron. And it's the same Chevron in this case, Your Honor, and to not violate any laws while out on bond. He is currently in violation of that bond order, Your Honor. He also has a 20-2186 theft by shoplifting case. The offense date is September 15th, 2020, and it has not been accused. On June 28th, 2022, defendant Otis Ponder did knowingly and intentionally go into the 1990 Donald Lee Hollowell Parkway Northwest in Atlanta property of Chevron without consent. The defendant had received a criminal trespass warnings from this specific Chevron gas station numerous times in the past. The defendant was seen wearing black pants and a white shirt, sitting on a bicycle right next to a gas pump. Number 2, talking to a customer. The defendant has also been previously arrested for the offense of criminal trespass involving this incident location, but keeps returning. The Atlanta Police Department found a glass pipe with brown stained residue inside, which is used to smoke narcotics, and it was located in the defendant's back pocket of his jeans. The defendant was arrested in all these events that occur in Fulton County, Georgia. Your Honor, besides the fact that he poses a risk of violating his bond, as he does have that previous case where he's in violation of his current bond order, he also poses a risk of reoffending, Your Honor. He has 15 cycles. Not only that, Your Honor,
the court is aware. Yes.
Yes.
Go ahead, Ms. Tortorella.
So, given the fact that he, as you heard from pretrial, he has a background, we're asking for that. In that open case, we're asking for that $2,000 surety bond. Nothing further.
All right, thank you. Ms. Kim?
Yes, Mr. Ponder is 26 years old, and he claims that he was he was riding a bike to avoid being hit by another cars. That's why he was passing through the parking lot of Chevron. That was his explanation. He has been here in Georgia for the last 21 years. He has one child who is 8 months, and he is currently employed. He has education of 11th grade. We would like to request for a signature on bond, and yet if your honor is not inclined to give him a signature on bond, we would like to request for $200, $50 surety bond, your honor, for first charge, and $250 for a drug charge, total of $500, your honor. Thank you.
All right, at this time, Mr. Ponder is gonna receive a split bond. It's gonna be $1,000 surety bond for count one and $1,000 signature bond through the jail for count two, for a total of a $2,000 bond. He is to stay away from that address on Donnelly Hollowell, and he is to have no weapons, drugs, or alcohol as a condition of that bond.
Thank you, your
Is there
honor.
anything further from either party?
So,
Nothing
Your Honor,
further.
count two is $1,000 signature through jail.
Through the jail, yes.
Okay.
All right, who do we have next? Best of luck to you, sir.
All right, number 12, Mr. Trammell.
Is there, can we go to him last, since that's gonna be a breakout case? I
He's our last-
apologize.
he's the last one in the room.
Oh, he's the last person. All right, we're gonna have to go into a breakout. Before we go, can we please have the history, Mr. Howard?
For Trammell, this is fourth arrest. I didn't see any violence in this history either. 2019 was the last arrest for misdemeanor possession of marijuana. 2016, he was arrested twice for marijuana possession.
Okay, that's it?
Yes.
All right, thank you. Can we be placed in a breakout, please?
Hi, Your Honor, before we are, can I inquire about Mills and Maxim?
Okay, sure, Ms. Falk. At courtroom 2,
Yeah,
well, are those medical resets or were they already released?
no, Mills is a medical research. He's at Grady, and Mr. Maxim, what I was told, waived his appearance.
Okay,
Yes, Your Honor, I submitted the waiver for Mr. Maxim, position 7.
all right. All right. Let's see who needs to be in that breakout. It would be Ms. Tortorella, Ms. Falk, Ms. Gant, Ms. Kim, myself, and Ms. Bridgewater.
No, Your Honor, I do not need to be in the breakout. I believe this is.
Okay, you don't wish to join us, Ms. Gant? You're gonna miss out on the fun. All right. Ms. Gant does not want to join us, but
Okay.
everyone else, if we could be placed in a
Well,
breakout, please.
let me put it this way. If Ms. Kim would like for me to join, I'm happy to join.
I'll be fine. Thank you, your honor.
Okay, thank you.
All right. All right, in the case of Latarvius Trammell, case number 22 CR 004145H, in which the defendant is charged with simple battery family violence with the offense date of June the 28th of 2021. He is going to receive a $3,500 surety bond. He is to have no further contact with the victim and stay away from the incident location. He is to have no weapons, drugs, or alcohol as a condition of this surety bond, and his case will be reset to the SAP calendar on July the 12th of 2022, whereby this case can be revisited.
And Your Honor, the victim's on the line and she would like to speak.
Okay, I will hear from the victim. Ms. Gordon, are you present?
Yes, I am
If so,
present.
you need to turn on your camera so that we can identify you.
Okay, let me try to turn this on.
All right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right. Of what the court is most interested is in whether you'd like to have contact with the defendant, whether you fear for him, but I will hear from you at this time.
I don't fear him at all. I think it was just an incident that happened out of him still having love in his heart for me. I do still want contact so he can have his daughter in his life. I'm in a better place in my life right now. And I just think it's just something that happened a year ago and it's just blown over at this point. And I do want him to be there for his daughter because it's the only daughter he has. She's only 5 years old and she needs her dad. And I forgive him for it. And I don't intend to do anything else farther than that. So that's all I have to say.
Thank you. I appreciate you making that statement. The ruling will stand. I will add that a third party can transfer the child at this time. Is there anything further from either party?
Nothing.
All right, best of luck to you, sir. I believe that will conclude this case. We'll now go to the case position, I believe it's 7. Courtroom 2 can be excused, so if there's no further parties there, we'll go to the position of Malieve Maxim, case 22 CR 004142E, in which defendant is charged with willful obstruction of law enforcement and disorderly conduct. Attorney Gant has indicated that his appearance has been properly waived.
And Your Honor,
right.
Your
Yes.
Honor, if I may request that I'm requesting a waiver of the reading of the allegations in the warrant.
Okay, or is this appropriate for a breakout that you're saying, Ms. Gant?
I do not believe that we need a breakout for this, Your Honor.
I can't control what Mr. Segura is gonna say, so if there's any chance that a breakout is necessary, this is really our last chance to ask for one.
Well,
But
Your Honor, I do apologize. I will request a breakout, Your Honor.
all right,
I do
at
apologize.
this time, before Mr. Howard, can you put the history onto the record? Then we'll go into that breakout.
10 total. This is 10th arrest. Last was May 2021, assault causing bodily injuries to a family member. That was out of Texas. It just says prosecutor accepts the charge, so I'm assuming that's open. It was that charge and unlawful restraint. He got a driving while intoxicated conviction, 2016. Suspended license. Another driving while intoxicated, and another one. He got a trespass that was dismissed 2021 out of Florida. Disorderly intoxication charge that was dismissed 2020 in Florida. That's it.
All right, if we could be placed in that breakout, I would appreciate it.
Oh, and he's a resident of El Paso.
Oh, okay.
Hold on, he got something out of Nevada too. Let me see.
Okay.
Oh, 2009 says resident with non-Nevada registration and reckless driving. 08. That's it.
All right, thank you. And I believe it'll be Mr. Segura, Ms. Falk, Ms. Kim is invited to attend.
Sure. I'll come.
Okay. And I believe Ms. Bridgewater.
Yes.
I think the judge is still stuck in the break. There she is.
All right, based upon the evidence before me, Mr. Maxim is going to receive a $3,000 surety bond, $1,000 for each charge. He is to stay away from the Top Dog Animal Supply, and he is to undergo a BHET. He is to have no further contact as well with the victims as named or the alleged victims, and he is to have no weapons, drugs, or alcohol as a condition of that bond. Is there anything further from either party?
None, Your
Nothing
Honor.
further, thank you.
I believe that will conclude our entire calendar. Ms. Bridgewater, will you please review it for me?
Certainly. Okay, everybody, once again, the reset date for the SAP calendar is going to be July the 12th. Position number 1 has been released, so therefore it'll be reset further notice. Position 2 is going to the SAP calendar with a $2,000 total split bond. Position 3 is reset further notice with a $3,000 SOB through pretrial. Position 4 is going to the SAP calendar with a $3,000 good bond. Position 5 was released, therefore it will be reset further notice. Position 6 is going to the SAP calendar with a $500 good bond. Position 7 is reset to the SAP calendar with a total $3,000 good bond. Position 8 is a medical reset that's rescheduled for tomorrow. Position 9 is going to the SAP calendar with a $3,000 good bond. Position 10 is going to the SAP calendar with a $2,500 total good bond. Position 11 is reset to the SAP calendar with a $2,000 total split bond. And position 12 is going to the SAP calendar with a $3,500 good bond. Are there any questions, comments, corrections, or otherwise?
Hearing none, we will be in recess until tomorrow, June the 30th at 2 p.m., which time Judge Law will be residing. Everyone take care. Have a great rest of your afternoon.